Hello again, and welcome to Law and Society, where legal and social issues come together with Andrew Stevenson. He is a criminal defense attorney right here in our area, right in offices in Lancaster. How are you doing today?
I'm doing fine, Mark.
We've reached, I feel like Casey Kasem, we've reached the number one spot on the countdown. This is a topic I have been wanting to talk about on this show since the beginning of it. And it is your Miranda rights.
It is.
You know, when to shut up.
Right. It's number one on my list of things you can do to get yourself put in jail. And essentially, it is talk to law enforcement without an attorney. Mm-hmm. Now, this is in a interview or questioning scenario. This isn't a traffic stop or meeting them at the supermarket. But it's when you're in custodial interrogation is the phrase that they use. And if you speak to the police, you shouldn't do so unless there's an attorney present.
Okay.
The answer of what to do, the answer of how to handle this situation, should you ever find yourself under arrest and being questioned, is very simple. It's 4 words. And they are, I want a lawyer. That's it. 4 words.
Okay.
Those are the magic 4 words to say.
What happens when you say that? Okay, so do you say this? You get the phone call. Hey,
I'll get to that in a minute.
Okay, yeah.
Let's go a little bit backwards.
Yes. Okay.
And all this stems from the famous case of Arizona versus Miranda.
Okay.
But to understand what happened in Arizona versus Miranda, you need to understand a little bit about what was going on in this country prior to the Miranda decision by the U.S. Supreme Court in 1966. Prior to Miranda, law enforcement routinely use coercive tactics to extract confessions from suspects. That would include beating, threats of force, telephone books, things like that. In fact, in the Miranda decision, the first half of it is the Supreme Court talking about all the police brutality that's been going on in the country and all the studies and all the incidents. So prior to Miranda, the issue in a case when there is a challenge to a confession or a statement was it voluntary? Was it coerced?
Okay. And
that's all the court was focused on. And there were some long-standing cases where people would be held for 3 days, 36 hours in question continuously, without food, without sleep, without water, by the police.
Put in a room and interrogated.
Yes, by rotating shifts of police officers. Those were the types of cases that the Supreme Court was analyzing to say, is 36 hours of straight questioning too much? So along comes Ernesto Miranda in 1963. And he was arrested at his home and taken down to the police station. And he was a suspect in a kidnap and rape of an 18-year-old girl.
Okay.
He was questioned for about 2 hours by the police and eventually signed a statement, which was a written confession of what he had done. And included in that confession was a statement in which it said he was not threatened or coerced, and the statement was voluntary.
Oh, he made that statement completely
of
his own volition.
That was part of the written.
Okay.
So they went to trial in the case, and the prosecution wanted to introduce his written confession that was signed by him. And his lawyer objected. And his lawyer said at trial, he says, listen, we don't know that Mr. Miranda was advised of his constitutional rights under the Fifth Amendment, Judge.
So these constitutional rights existed prior to Miranda?
They existed prior to Miranda, yes. Okay. It's the Fifth Amendment, the right to remain silent and the right to counsel that stems from the Fifth Amendment.
Gotcha.
But no one told anyone anything. So the question was whether or not, the only question was it coerced? Was it forced? And in the Miranda case, his lawyer said, well, no one told him his rights, Judge. They shouldn't be allowed to use this statement unless they told him his rights. The judge looked at him and said, the statement's coming in, move along. Ernesto was convicted, surprisingly, and got 20 to 30 years in prison.
Okay.
He appealed to the Arizona Supreme Court, and the Arizona Supreme Court basically said, his confession wasn't coerced, he wasn't beaten, therefore it's good.
All right.
And of course, he applied to the United States Supreme Court. I'll tell you the rest about what happened to Ernesto Miranda at the end of the show, because it's kind of a fun little story.
Right, but it did make it to the Supreme Court.
He appealed to the United States Supreme Court, and when the Supreme Court got it, they basically said, and this is what they said, it's a legal statement, but I'm going to break it down. They said that the prosecution may not use statements stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Nowhere in the Miranda decision do they necessarily say exactly what you have to tell them. They list some ideas and so forth. But basically what that means, what the Supreme Court said in 1966, was that the police cannot use what you say to them in response to their questioning unless they first advise you of your Miranda rights.
But then that's very specific. It pertains to police questioning.
Police questioning, and you have to be in custody or deprived of your freedom in a significant way.
Don't have to be under arrest.
You generally have to be under arrest.
Well, if they're taking you into custody.
Right.
Now, if you, we'll get into the whole walking into,
Yeah, so what are your rights?
Yeah.
And what they say to you, and you've heard this on TV many times, but you have a right to remain silent, right to an attorney. If you cannot afford one, the court will appoint one for you. Anything you say or do can be used against you, and you can decide at any time to exercise these rights. Those are the basic gists of what the police officer has to say. It does not have to be verbatim. There is no magic word. If they skip one, it's fine.
Those old shows where they pull it out of their hat, the little card.
They have the card, and officers still carry the cards.
Do they really?
Yeah,
okay.
They still carry the cards, yeah.
So that way they know they're getting
They
it
just
right.
read it right off the card. Or they have a sheet of paper they present to the suspect in the interrogation room, and they read it right off of there, and they have the person initial. So what this doesn't mean is that they have to read you your rights if you're arrested. One of the most common things people tell me when they call me is, I got arrested, the police didn't read me my rights. And I say, did they ask you any questions? And they say, no.
Then no problem.
They only have to read you your rights if they're going to want to question you. All righty?
Right.
So, for example, if you were accused of shoplifting, and the police, you get stopped by loss prevention, they take you back, they get a whole question from you. Before the police get there, you've already given a confession, they've got you on videotape, you've said you're sorry, the police just is there to place you in handcuffs to take you to the county jail.
Let's pause there for a second. So there are loss prevention people, security guards, if you will, at your stores. Are they police? Do they have the same obligation to read you your rights? Is there any legality there at all?
They are.
Do you have to talk to them?
No.
Okay.
You don't have to, but most people do.
Yeah.
Yeah. So the police are only required to read your rights if they want to question you and they want to be able to use what you say in court. That's it. Now, it doesn't apply to voluntary stuff that you tell them. A lot of people who get stopped start running their mouths.
Thinking, okay, he hasn't given me my rights. There's nothing they can do.
No, they just say they say a lot of things. I see it most commonly in DUI stops, where people get put in the back of the cruiser. The doors are closed. They've been placed under arrest. They're in the back of the cruiser, and the officer's usually securing the car and pulling it off to the side of the road. Everything from, oh, God, I'm so drunk, to I hope he doesn't find the pot I have underneath the front seat.
I'm not as think as you drunk I am.
Yeah, stuff like that. So those are voluntary things that you can run into.
Now, again, if you just blurt that out, that's evidence,
voluntary statement. If you're in the middle of if you're in the middle of being processed in at the county jail, they've read you your rights. They haven't asked you any questions other than your name and your address, things like that. And you say, I really am sorry. I wish I hadn't hit that guy so hard. They can use that. So
Miranda really only deals with this one specific, it's questioning after in custody.
Yes.
Yeah, once you're in custody.
Now, it doesn't always have to be questioning per se.
Okay.
There's also something else called the functional equivalent of custody. And there was a very famous case called Rhode Island versus Innis, in which a taxi driver was robbed by a guy who had a sawed-off shotgun. And he gave a description to the police, and a police officer saw a gentleman walking down the street who matched that description and placed him under arrest. But he didn't have a gun with him. He didn't have this shotgun.
Okay.
And he was placed under arrest, and he was read his Miranda rights, and the guy said that he wanted an attorney. So he was going to be transported to the police station by some other officers, and these officers were specifically told, don't question this guy. He's asked for a lawyer. He's invoked his Miranda rights. Leave him alone. So as they're driving to the station, the police start talking amongst themselves, saying, it's really a shame about that gun, that we haven't been able to find that gun because we have some special needs. We have a special needs school nearby, and a lot of special needs kids attend this school, and we would really hate for one of those children to find this gun because God knows what could happen. Yeah. At which point, the suspect in the back of the police cruiser speaks up and says, okay, I'll take you to where the gun is. I don't want someone to get hurt. That's called the functional equivalent. It's steps taken by the police to elicit confession of sorts without directly questioning. There was another famous case, which was called the Christian burial case.
Yeah, let's get to that one. I love the stories, and we're real close to a break, so I want to save the Christian burial case for just...
Let me finish this one, and then we'll take a break. Anyway, the Christian burial case was the same thing. The suspect was accused of rape and murder of a young child, was being taken into the police station, and the officer starts talking about what a shame it is that the kid's not going to get a proper Christian burial, and the suspect went. So it doesn't have to be direct questioning, but it does have to be custodial questioning. You have to be in custody, which we can talk about what that means when we come back.
Yeah, let's do that. I was just reminded when you were talking about that of the officers, and I don't know if it's real or not, but I saw it on television. They used a Xerox machine
as a
lie detector.
Yeah, same thing, same idea. Yeah.
We'll be back in just a couple of minutes. You're listening to Law and Society. Before we take the break, Andrew Stevenson is available, StevensonCriminalDefense.com.
Yep.
If you find yourself hearing those words that we're talking about, best give Andrew a call.